Everyone, it's Bonnie Fleshman here from Douglas Realty, and today we're going to be talking to Sean Bittinger. He's an attorney and owns a title company, and I'm going to let Sean introduce himself. So tell us a little bit about yourself, Sean.
Hi, thank you, Bonnie. I appreciate the opportunity to be here. My name is Sean Bittinger. I'm an attorney with the law office of Sean Bittinger and Maryland Title Group. I've been practicing law for about 16 years. Most of my practice is focused on real estate. It's what I've always been focused on, and that's what I enjoy doing. And I like building relationships with agents because I try to look out there on the long view on things, and I believe that a good relationship with realtors is essential to continuing a successful title company.
Well, good. Yes. And Sean's one of my favorite title companies. So I just thought it might be a good opportunity because a lot of people don't really understand what a title company does and what their role is. So I'm just going to ask him a few questions, and hopefully we'll be able to answer any questions you have. And of course, we're always available to contact us later if you need us. So basically, what is the title company's role during the closing process when purchasing a home?
Yeah, a lot of people don't know what we really do, and most of what we do is behind the scenes. We obviously get to settlement and present the loan documents, but before we get there, we're doing 95% of our work happens behind the scenes that no one sees. So when a buyer and seller get into a contract that they're going to sell and purchase real estate, that comes to us, and then we begin working. We start by researching the title. That means we go back in the chain of title for 60 years in Maryland when it's a purchase, and we look at the title chain going back from owner prior to the prior. We also go through and look at all the covenants, conditions, and restrictions that can go along with that property, easements, anything that would affect the title. We have to search for liens that may have been unpaid or missing heirs in the chain of title to make sure, because what we essentially do is we issue title insurance policies. We issue two typically at a settlement. One is to the lender, ensuring that the lender's lien is good and they're going to be in the first lien position. And we ensure the owner that they're right in the property, that they'll have that property subject only to any liens that they're responsible for against the property. But we're searching back 60 years to make sure that the title is clean and good and marketable, and that seller can convey that whole property and all those bundle of rights to the new owner. When we get settlement, when we present the loan documents, and we go through them and explain the promissory note and the deed of trust, and that way, and then we ultimately we are responsible for the money. So we'll disperse the money in accordance to the settlement statement to make sure that the current lender, if any, is paid off, that the seller receives their money, that the deed makes it to the courthouse and all the applicable taxes are paid, and that it gets recorded. That's
a lot of paperwork, a lot of research that goes into what they do, and it's actually a very important aspect when buying a home to make sure that you're investing money in a property that you could sell again if you wanted to, because basically if you have title issues, you have problems conveying that title to somebody else. So I think one of the questions I get from a lot of the buyers is, what is title insurance and why do I need it? So maybe if you could explain the purpose of it and how important it is, that might help me out.
Yeah, absolutely. Title insurance essentially differs from other insurances because title insurance protects from the time that the owner, all things prior. Typically when you get insurance, for example, car insurance, that protects for future things in the event that you're in an accident in the future. Title insurance is protecting, you from anything that would have happened prior, like we said, missing heirs or an unreleased mortgage or forgery along the title chain. So it's going there and it's protecting back. Also, that's something that's different with title insurance is it's a one-time premium. It's not something that you pay, every so often to re-up. You pay that premium one time. And if you have a $300,000, $400,000, $500,000 home or so, you're protecting that for as long as you have an ownership interest in that property. That one premium that you're paid goes and stays in effect. That policy will stay in effect. There are two types, as we briefly spoke about prior. There's a loan policy that protects the lender. Now, the homeowner has to purchase that. It's required. Every lender in the country requires that they have title insurance, and it's paid for by the owner for the benefit of that lender to ensure that their lien is good, that there's nobody that can come in and usurp their lien and the property. The owner's title insurance protects the owner. It ensures that this person who bought it has the for all the rights that are available for that property, that there is nobody else that has a claim to it. And if somebody does have a claim to it, that title insurance comes into play. You file a claim with them, and then it is an obligation and the duty of the title insurer to hire an attorney and protect your interest in the property.
So
So
basically, you're hired attorney in advance just in case you have a problem. So I
that is
think a lot of
correct.
people panic when they have a title issue and they call an attorney and find out how much it is. And then they call me like, I have a problem. And I'll say, you have title insurance. So, you already have an attorney. You don't have to go outsource it and ask somebody else questions. I know it's happened to a few of my clients where there have been issues that, have come up with the title, and it's really comforting for them to know that they have somebody out there looking out for their interests in their property. So,
yeah, absolutely.
so who
Considering
pays?
how large it is, that
Oh
asset,
yeah,
the fact that you can protect it with a one-time fee. I'm an attorney
exactly.
in the state, and I still purchase title insurance when I buy properties for that very reason, because to me, it's absolutely invaluable.
Well, there's so many things. I had a deal, and it was my seller, and right after settlement, they found a lien that was recorded in the wrong county. And so he goes, oh yeah, that is mine. Yeah, I did that. So fortunately, he was a good guy and he paid it off. But there are things that are misrecorded. There are things that are misrepresented.
Absolutely.
There's fraud. There's all kinds of reason to protect it. And it's usually your biggest purchase, your biggest asset. And you have car insurance. Why wouldn't you want to have like insurance protecting your interest in your own home? Who actually pays for the lenders and the owner's title insurance?
It's paid for by the homeowner. It's required that you, like I said, stated prior, you have to buy it if you're buying a property and you're taking out a mortgage. You have to buy lender's coverage, and it's paid for by that homeowner. And but the thing is, if you buy owner's coverage at the same time that you're buying that loan policy, you do get a discount. It's a simultaneous issue. So therefore, the title insurance, you get a discount on it. If you had bought that owner's policy at a different time in the future, you wouldn't be able to avail yourself to that discount that if you did it at the time that you purchased the property when you got the original purchase money loan.
Right, right. Well, that's good to know. I didn't realize that there was a discount associated with buying it at the time of sale. Normally, that's the only time people really think about it unless there's a problem. And then
Correct.
if they didn't buy it, it's too late once the problem is recognized anyway. So
that's correct. An ounce of prevention worth a pound of cure. So yeah, I get it at the time.
And most of the time the buyers are asking for closing cost help from the seller. So might as well lump this in there with that. I mean, there are a few stubborn people that refuse to buy it. They think everything's going to be fine, and we have no way to protect them then. So it's kind of scary to me that they would be willing to invest their money and not protect it. Now, are the premiums for the title insurance regulated?
Absolutely. There are different underwriters: Fidelity National Title, First American, Westcor, Security Title Guarantee Corporation. All of them have to file their rates, their premium rates, with the state of Maryland, with the Maryland Insurance Administration, which governs title companies. So the premiums are set. So it's not, for example, when you go to a title company and they may have multiple underwriters, but they can't pick what the premium is, because they have to go off of the premiums that are filed with the Maryland Insurance Administration, with the commissioner. And if they don't, that title company could be in serious trouble for not doing that. So it's not a situation where title attorneys can pick arbitrary numbers when it comes to title insurance. It's set out there. It's promulgated. We have to abide by that. Our software is even set up to do that and to basically calculate the rates pursuant to our underwriters' premiums. So it's not a type of situation where you have to negotiate with it, because it's already set forward. It's listed.
It's already been taken care of for the consumer to
Correct.
protect the consumer. So basically, that's what they're trying to do. So when a buyer is coming to closing, sometimes they're not coming anymore, though. That's something new.
That is
But when
true.
they are attending a closing, what should they have with them? What do they need to bring?
That's a great question. One of the things that they always need to bring is ID. It's typically good to have two forms of photo ID if you have a passport, driver's license, or identification card, but minimum of at least one. It's always good to check with the title company, though. Call them and say, hey, what do you want me to bring? What do you need me to bring to settlement, to make sure, and they'll let you know. It used to be a time that you would bring your cashier's check along with your ID or so forth. Now, typically title companies aren't taking cashier's checks, but call your title company, talk to them, say, hey, what do I need at settlement? Just confirm. It's always a good idea because maybe the lender has a 2 ID requirement, or maybe there's something else that they needed. They may needed some other type of verification or proof that a bill was paid. The lender might. So talk to the title company and they'll let you know specifically in your transaction what you need to bring aside from your ID, which is a given in every transaction.
Okay. And then I have sellers ask me all the time if they need to bring their deed. So,
You do not need to bring your deed. It's not like a car title where you show up and you sign over the back of the title and you hand it over to the other person. The title chain that you would see in for real estate, it's filed in the land records. Every transaction is to be memorialized there. So we create a new deed each time from seller to the new buyer. Our deed references the prior deed from when that seller purchased it from the prior seller. And then that deed will reference the prior deed. So there is a chain in the land records that you can trace the deed back from person to person to person, from grantor and grantee. That's how they're indexed in the Maryland land records. So we can go backwards that way. They do not need to bring their deed. Once the new deed is signed and subsequently recorded, the old deed is just paper for historical purposes for you because it's memorialized in the land records and not necessary.
right.
Going forward, there are people now that'll say, hey, I got this notice after settlement that I can get a certified copy of my deed for $75 or $80. That's not necessary. That if you ever wanted a certified copy, they typically cost around $5 depending on the county. It's not necessary to get them though, because once it's recorded, you can download copies of it for free. This is just companies finding a way to essentially prey upon people, for lack of a better word. It's not illegal what they're doing, but you would be overpaying, paying them $80 to get you a
Yeah.
certified copy of your deed, which you typically don't need. So we tell people to be on the lookout for that.
Right. And they could just look it up in the land records. It's
Or ask us and
free.
we'll send them a free
Yeah.
copy. The original, typically, things are hit a little bit of a lag right now because of the COVID. But typically you will get your original recorded deed back in about 3 to 4 weeks after settlement.
Right. And that's really all most people need, and they keep
Correct.
that secure and everything. So back to title insurance a little bit. What is not covered by title insurance?
Okay, great thing. There are certain things that aren't covered, but one of the main things that are not covered would be liens that the owner, consented to or was responsible for. So, for example, if I bought a house and then subsequently I stopped paying the IRS, income taxes, and the IRS, comes and puts a lien against my property and subsequently tries to levy it, I cannot file a title insurance claim for that because I caused that lien against the property. It wasn't a lien from a prior person. I'm the cause of it. Or if, for example, I got into a dispute with my credit card company and didn't pay them, and they took me to court and sued me and got a judgment and created a lien, that's not something that I could file title insurance for because it was my responsibility. I caused it. The title insurance is essentially for things that you didn't know about that were caused by other people. It's a big difference that otherwise people could default on loans or financial obligations or not pay their property taxes. If you don't pay your property taxes going forward from the time that you own the property, that's also excluded from title insurance coverage. Otherwise, people would be able to benefit by not making payments and throwing it back onto the title insurer.
Right, I get you. Okay, so typically, how long would a closing take?
All right. Well, closing would take approximately about 45 minutes, but that depends. It depends on how quickly people sign. Some people are very excited and sign quite quickly. Other people have many questions, but you would typically say around 45 minutes for a settlement. Could be an hour or so, but usually not longer than the hour.
Okay, and we used to be able to use cashier's checks. Now we have to wire funds, and why do we have to do that now?
All right, there's a couple of reasons why we go with a wire. One of the reasons is it is so easy now with modern technology and how fabulous color printers are for people, nefarious people, to duplicate or create what would look like a cashier's check. And it's happened before where they've shown up, given what we thought were good funds, not necessarily with us, but the title insurance industry. And then it turns out that that was created at home or someplace not actually received from or taken from a bank. The other thing is there can be a delay even with a good cashier's fund, because depending on how the banking goes, because banking crosses state lines, they may use an automated clearinghouse that has a routing number in another state. So those funds, even though they're legitimate funds that are certified by the bank, they may not be available for up to 48 hours. Because that's not available for 48 hours, and Maryland is a wet state that requires the funds to be dispersed, at the time of settlement, we could have a lag. If somebody brought a $50,000 check and the funds were not available for 24 or 48 hours, that is problematic, and we wouldn't have a complete transaction at that time. Whereas if you send a wire with a federal reference number, not an ACH or bank-to-bank type of thing. It's a wire that goes from one bank to the Federal Reserve and subsequently to the other bank. That is almost instantaneous, and that can't be pulled back. It can't be taken back by a party. The funds are gone. It's actually it's more secure that way, and it protects all the parties: buyer and seller, the lender, and the title company.
So then the deal's done, they get their keys, and life goes on, right? So that's a
That is
good
correct.
thing. I know I have worked for some builders in the past, and until that, the funds can be dispersed, they won't hand out the keys, and some sellers too, and I really don't blame them.
No, not
So
at all. They
yeah,
absolutely have a
because they
right
need their
to
money.
insure.
They're giving you their asset, and they're not getting their payment for the asset. So when a person takes title to a property, they have options, and married couples have options, single people, people buying as groups. So there's different tenancies that they could choose. And I know you send out a letter asking them how they want to take title, but a lot of people don't understand the ramifications. Could you tell us a little bit more about that?
Yeah, absolutely. We're talking about individuals in Maryland. If it's one person, they're going to be the sole owner. So there's no other options at that point, speaking individually, how you would hold tenancy in Maryland. Sole owner. If it's more than one person, there are options with that. One of the options, if there are two people or more, is tenants in common. Tenants in common, it's essentially divided interest in the property. It can be 50-50. It could be 60-40, it could be 70-30, 80-20, any way that you want it to. If it's three people, it could be, everybody has a third. Or if it's four people, everybody has a fourth. It can be divided up. The thing that's about tenants in common is there is no protection available for judgment liens. So, for example, if two people own a property as tenants in common, it would be, typically it's stated in the deed. If they're tenants in common in Maryland and one of those people gets a judgment against them, for example, we'll say the IRS as prior, that judgment would attach to that person's portion of the property. Right? So that's a big deal. Even a judgment not from the IRS. So, for example, we go back to the credit card. If you have a credit card and you don't make payments and they sue you and get a judgment and create a lien, that would attach to your portion of the property. That being said, also, there's another thing that's very important with this. When somebody passes, when you have two people that own the property, or three people, or four, but when one of the tenants in common passes, their ownership interest goes to their estate. And therefore, it needs to be handled that way. So That's what
So
happens
a
when.
lot of times that if there is some sort of lien or something attached to that other person's portion, if they don't have the money to release it, then that forces the house to be sold.
Absolutely. It creates problems, and it obviously, you can see in those situations where it can create a little bit of friction between the owners. If somebody has, because typically with a property, you can't sell without, the other person, agreeing to it. And if they have unintentionally encumbered the property by getting a judgment lien against them that subsequently attaches to the property, it creates friction between there and can lead to a lawsuit, between the owners of the property trying to figure out how to do it. So it's just something to be aware of. It's not that tenants in common is a bad thing, because some people want to have it pass something on to their estate in the event that it goes. But
Right. And,
it's just
as long as everybody knows
understanding.
up front what the ramifications of this type of title, I mean, it might be two brothers buying a house, and yeah, there could be things that happen with one or the other, and that could happen, but that maybe that's the only way they can get the house, and that's what they want to do. So, and then there's a special tenancy for married couples.
Correct. That's a tenancy by the entirety. That's a husband and wife. That gives them very good protection against judgment liens. I do want to point out, because I had said the IRS there. There was a Supreme Court case in 2000 that made its way there, that they said that there is any IRS lien against one party, and a husband and wife would attach to the property. That case came out. Aside from those types of situations, if, for example, the husband had a credit card that he didn't pay and it was only in his name, no judgment lien would attach. You would need to have a judgment lien against both the husband and the wife to subsequently attach the property, except for the IRS in that situation, because otherwise the federal government would trump that tenancy and allow there. But that also has a right of survivorship. In the event that the husband passes, the property automatically, by operation of law, goes to the wife. She doesn't have to file a new deed. She doesn't have to do anything at that point. She becomes the sole owner then of that property. There also is a joint tenancy. It's because the tenancy by the entirety, you have to be married at
Right.
that point. But you can also have joint tenants. In that situation that you spoke about, where you had two brothers buying a house, they can decide to be joint tenants. Where they, now that also would provide protection from them on state liens. For example, if it was Visa had a judgment against one of them, it wouldn't attach to the property. The difference with that is, in joint tenancy, like with a married couple, there is the right of survivorship. The parties have own 100% undivided interest in the property, which means that if brother dies, the next brother takes all, winner takes all at that point. So it doesn't go to the estate. That's something to be considered if that's what they wanted to do. So you get the protection from a lot of judgments that way, but you lose the ability to dictate where the property would go, because your estate doesn't take control. By operation of law, it would have passed to the surviving tenant. So you have those four options in Maryland. You have the sole owner, you have the tenants by the entirety for married couples, you have the joint tenancy, which has a right of survivorship for people, and then you have the tenants in common.
Right. Yeah. So it's a big decision to make. So I feel like people should listen to this and get educated, and then reach out to their agent and their attorney to just figure out what the best option for them would be. So there's some very important documents that are signed at closing, of course. So
Yes.
some people ask a lot about the closing disclosure, the note, and deed of trust, those type of documents. And I do think some documents are very redundant and you sign the same things 10 times, but I feel like these three things are vital, that they understand what they're signing. Would you mind giving us like a little overview of those?
No, not at all. You're absolutely right. The closing disclosure that the buyer gets basically details their loan. When you see on page 1 of it, it tells you the amount of money that they're borrowing. It tells you the interest rate. It tells you the principal and interest payment. It tells you the total. It tells you the total monthly payment if they have escrows. Most lenders are escrowing for taxes and insurance, so you would see what your total monthly payment is. It also tells whether you have a prepayment penalty, and it also tells if there are any balloon payments. It has the amount of money that you need to bring the settlement, and it has the closing costs. You get to page 2 of it. It itemizes and gives a breakdown of the closing costs by alphabetical sections, A, B, C, D, E, F, G. Page 3 of it essentially summarizes the transaction. So you would see, you add your closing costs in, the purchase price of the property, anything that you have to reimburse the sellers for, such as property taxes that will be paid in advance. And then it takes your loan amount, what you're borrowing, and subtracts it from those numbers and gives you what you would need to bring to settlement, the amount of money to complete the transaction. It's very informative. It's all about your loan. Everything that you need to know about your loan will be listed in your closing disclosure that way. All
that document itself should not be a surprise at all, right? Because they
No,
get
it
to
should
review
not.
it prior to closing. So
Correct.
there's an
The lender send
opportunity
it
to
to you.
ask questions and make sure they understand everything. And there is a law out there that they have to receive this document 3 days prior to closing. So they have the opportunity to review it. And that's why we have a closing disclosure now instead of the old HUD 1, to give the consumer a chance to review it, the buyer anyway, a chance to review what's happening financially with the transaction and what their final payment's going to be.
You're absolutely right.
It's a
You
good
should have seen
document.
it. Yeah, you should have seen it. The days of getting to the table and being surprised are supposed to be gone. All right.
Yeah, they're supposed to be gone.
Yes. The next document that you talked about was the promissory note. That is where you personally obligate yourself for the repayment of the money. The note's anywhere from 3 to 4 pages. It lists the loan amount in there. It relists the interest rate that you would have seen in your closing disclosure, and it has the principal and interest payment. That's the amount of money that the lender gets to keep each month. Your escrows are not listed in the note because that depends on whether you have escrows or not. It also says in there whether you have a prepayment penalty or not. Typically, there's no prepayment penalty in Maryland. It also talks about your failure to pay and that you're personally obligated. And anybody who signs that note can be held liable. So if 3 people happen to buy a property and they all signed the note, the lender can go after all 3 of them if they default on it. They can go after 1 of them, 2 of them. They can sever that and say, hey, this is the person who has the money. That's who we're going to go after. So if you have a situation where somebody's like, oh, I'm just co-signing for somebody to get a loan. If you're co-signing for them, you are as equally obligated for repayment of that money as the person there. So there's no situation.
And the whole amount too, right? You know,
Correct.
You're responsible
Absolutely.
for the whole amount if you sign it, whoever signs it. So
that is correct. The note is where you personally obligate yourself for repayment of the money. And that is something in which the lender can, under default, can go after somebody for non-payment personally, attach wages and do things such as that. The deed of trust that you talked about, that's what creates a lien against the property. You go to the bank and say, hey, I need to borrow X number of dollars. And the bank says, yeah, okay, we did an appraisal. We'll loan that amount of money. That deed of trust, you're giving a legal interest in the property to the bank in return for the money. It makes the property collateral. The home and the loan get tied together. You make payments, the home is yours. If you don't, it says in that deed of trust that there's a power of sale, that the bank via trustee can sell that property in a foreclosure, to an attempt to satisfy the debt. If not all of the debt is paid at foreclosure, then they can still go after the people under the note and make them be personally obligated for whatever deficiency.
right.
So the trust allows the bank to foreclose. The note makes the person personally obligated for the repayment of the money, and the closing disclosure tells you how the money in the transaction, how much money you need to bring, what your interest rate is, and about your loan. Those 3 documents are extremely important in the closing. You might sign 150 pages of documents to go through, but those 3 documents are paramount.
Right. And the note and deed of trust are also recorded, as is the deed. So that there's records of it at the courthouse. So they're going to find you.
Right. Yeah. The deed and the deed of trust are, but the note is not actually recorded. The original note goes back to the lender.
Oh, okay. So it's just the deed of trust that gets recorded then.
Correct. Yeah. The lien against the property. The promissory note stays as a contract that's not open for public knowledge. Now, it is public knowledge that there's a lien against the property because that gets filed in the land records. But that promissory note stays as a private contract between the bank and the borrower.
Okay, great. That's good to know. And
Mhm.
then some people order a site location survey or a stake survey, and I know there's
Right,
several kinds of surveys, and
there are.
but they're not required anymore all the time. So,
No,
what is your opinion on those?
sure. That's there are three main types of surveys that we're going to talk about. One is location drawing. That is the simple survey. There's a boundary survey. That's where they come out and stake the ground and say, here are the corners of the property, and this blade of grass is on your property, and this blade of grass is not. And you have what's called an ALTA survey. That is a boundary survey plus. That is rarely used. All right, I'm going to start with the location drawing because that is the most simple and the most utilized. You might look for a location drawing survey that might be $200, $250, somewhere in that range, depending on the surveyor. Keep in mind, though, it has pretty much all of them have a plus or minus of 3 feet.
Right.
It's something that you should be used to tell exact. It gives you a general idea where the house sits on the property, and they're generally not required by lenders now. It's clearly in most cases up to the homeowner whether they want to do it. And when in situations where people purchase at settlement a survey, I'd say 99% of the time they're getting a location drawing, not going to the boundary survey.
Right.
There are certain people that want a boundary survey. Now that is anywhere from $900 or $1,200. You get a quote for that. Depends on the size of the property there, and that's extremely specific. It takes several weeks to do, and as stated prior, it is meant to tell you exactly where your property ends with specificity. The thing with those is if people have a situation where they want to put up a fence, or if they believe that they could be entering into maybe a dispute or a contentious situation with a neighbor, that's typically when you go to the boundary survey. And some people just want them anyway, but rarely do people pay that cost initially.
Yeah. It's expensive
So,
to buy a house, so I guess it's hard, but I do recommend them for people who want to add additions,
sure.
fences,
Well,
decks, or if something looks odd with the neighbor's property, because like
yeah.
you said, there could be a 3-foot differential and it could create some sort of stress. And
Yeah,
sometimes,
without a doubt. If you're, and I tell people, look, if you're putting a $75,000 addition onto your house, get the boundary survey to make sure you're not running into a restriction line or another problem. I mean, if you're doing 75,000, you don't risk it by not doing the boundary survey at that point.
or
Same
even
thing.
fences can be so costly now. I mean,
Absolutely. Depending
people are
on what
building
type of fence
vinyl
you put
fences.
up.
It might be $30,000 worth of fencing out there, and I mean,
Absolutely.
it's a high risk to try to measure it with a measuring tape from the back of your house from a site location survey that's already off by 3 feet, maybe anyway.
Yeah, that's there's no way that I believe that you should put up a fence. That's my free legal advice on this. Do not put up a fence without the benefit of a boundary survey, because if you guess wrong, it's that person actually can knock your fence down. All right, they don't have to go to court. Self-help is available in Maryland, whereas if your property, or for example, if your fence encroaches off your property on the other person's, they have the ability to knock your fence down without your permission or anything because you went onto their property. Same thing with trees. If you have a tree and the part that your limb crosses over onto the neighbor's property, they can cut it off.
Yeah, I actually did that myself. They weren't home. The tree had a lot of dead limbs and they were falling all over my yard, and they almost, in a snowstorm, almost hit my sister-in-law and husband in the head. And I'm like, all right, I'm finally trimming this tree. I can't take it anymore.
Maryland law allows a self-help in that area where there's encroachments over the property for like a fence or a tree limb or so forth. So yeah, it's an important thing. Get the boundary survey if you're
I
doing.
think the surveys cause a lot of tension and arguments between neighbors too. So I
Yes.
think, they're not perfect either. And, it can cause some friction. So if that's a big concern of yours, you have to think of that before you buy the house, and what you want to do with your property to make sure that you're actually able to do it on the lot that you buy. So I think it's a good idea to have a survey. I encourage all my clients to have at least the site location survey, because it's not that expensive, and at least make sure your main structure is on your lot, and part of your
Yeah.
house isn't encroaching, or your garage isn't encroaching on
Driveway.
somebody else's driveways. You should know what
Yeah.
you're getting into. I mean, to me, like, a shed is a shed. If my shed is somebody's lot and I have to move it, then I'll move it. But maybe it's a $50,000 shed,
Yeah.
so that's more like a garage. So I mean, it really depends on what might be suspect, whether or not you might need a boundary survey, or how long that thing's been there, that object that's been there. Maybe the fence looks like it's 100 years old. So, and maybe, it's probably all right, because obviously nobody cares. So that kind of thing. So, I mean, it's definitely something to talk about and consider, and just think about what your goals are with your house, so that you know that you're buying the right property, and make sure that you're getting what you think you're getting. So, lately, I've been doing a lot of estate sales. So what is different with an estate sale?
Okay, so when you have an estate sale, there's typically, at that point, there is usually a will, or if the person died without a will, you have to go have a PR appointed. That means that somebody has to go to the Register of Wills and open an estate. So if Mr. Smith passes, and Mr. Smith was the sole owner of a piece of property, and let's say that he had a will in this situation, and his will typically names a personal representative. So Mr. Smith's personal representative takes the death certificate and the will, goes to the Register of Wills and opens an estate. They will give, the Register of Wills will give that personal representative letters of administration. That means that that's the person that's responsible. They're appointed by the court now. If it's a will chosen, by Mr. Smith prior, when he was alive, but appointed now by the court with the powers to sell the property and administer the estate. They become a fiduciary of the estate. They're the ones that sign the contract of sale as the personal representative. They sign the legal documents. The money then goes to the estate. There has to be an accounting that has to be done. And the money has to be, split up according to the will that Mr. Smith had, done in his life.
I think there's a misconception for a lot of people. They think at closing, well, she gets half, I get half, and he gets, they think they get the money, not that it goes into an account for the estate. And a lot of people close the estate account out prior to selling the house, which you
absolutely
can't do that. They're going to make the check out to the estate. You're going to have to open another bank account and put it back in there and follow all the
absolutely. For example, that PR has to go get an EIN, an employer identification number from the IRS. Not that hard to do. You can do it online, but they have to do that, and typically have to file a tax return for that property being sold. The money goes to there. So even if it states in the will that that PR and, for example, that PR's sibling are splitting all the proceeds 50-50, they cannot summarily just take the money at settlement, and the title company can't give them the money. The title company has to give all the money to the estate. It goes in the estate's account. There has to be an accounting filed with the Register of Wills, because remember, that PR is a fiduciary. All right, they have a legal obligation going to carry out according to the laws of the state of Maryland and the wishes that are listed in the will. And then the money gets disseminated to the applicable heirs at that time. Go ahead.
Does someone need to hire an estate attorney, or is this something they can do themselves? What do you really recommend?
What I recommend is, I hate saying that people, you definitely need to hire an attorney, because it seems very self-serving. If it's a complicated situation, when the person doesn't feel comfortable with it, I think that they should, at a minimum, consult with an attorney, even if they don't,
That's what I tell my clients. You need to consult with someone, because I'm not an attorney. I don't know if anything's changed or not. I know sometimes it's pretty simple. There's only one thing to do. Sometimes it's kind of complicated. Like
Correct.
you have to get everything appraised and you have to, pay taxes on maybe furniture and things. I mean, it can be complicated. So
Oh, absolutely.
I do recommend they at least consult and find out exactly how many notices has to be put out, how long the account has to stay open, when you can disperse funds. I don't know all that. I don't want to be responsible for that. I know I am the PR for these people. Haven't passed away yet, but for several wills, and it makes me nervous already. And I will probably be calling you, Sean.
Please do.
Even though it's probably you're not an estate attorney, but you'll probably be.
I've done estate administrations and created wills and
Oh,
that.
good.
That's
Yeah.
another area of the law that I have done.
It kind of all ties together in a little way anyway.
Yeah, it absolutely does. So that's why I kind of say I'm like, oh, you definitely need to hire an attorney because, like I say, it does sound self-serving.
Well, I just think it's important that you do it right because I've tried to sell properties 20 years later and they're like, the estate wasn't closed out properly. You can't sell this. I mean, It was a property in Arnold and I never did get it to closing because they even had an attorney and he didn't close the estate out, right? Because they said this property wasn't referenced in there. It was like they didn't tell him about it or he didn't know about it. Something happened with this one piece of property. It was just unimproved land and I just nobody had all the information to get the mess straightened out. And nobody had the money to do it, even though I took my lady down to the courthouse and we tried to do it without money. It didn't work.
Yeah, that's also a thing. Keep in mind when people go to the Register of Wills, they can give you the forms or tell you what forms you need to fill out, but they cannot give legal advice, nor will they.
No.
So you'd either consult with an attorney. So if it's not something that is starting to get, I would say, maybe more exotic or complicated, or the person's not comfortable with it, at least consult with an attorney.
There were like 9 heirs, and they'd all passed away but one. So they thought that the one got it all instead of the kids of the other heirs, and nobody knew where anyone was, and the family was all disjointed. They were in different states, and I couldn't help them. I mean, they don't remember their people's names when they were born, and you're trying to look all these. It's like really a lot more complicated. It's much easier to do it right the first time is all I'm saying. Because if you wait a long time, you're screwed because I don't think you're ever going to get that mess straightened out.
It would be difficult. And also
I have tons of cousins too I have cousins I probably never met yet, So, I mean, I come from, my parents have big families and, we have a lot of people. There's just a lot of people. Yeah. And I mean, when we were kids, we were more in touch, but now I don't know where everyone is. I have no idea where all my family members are. So if it wasn't for Facebook, I probably wouldn't even know I had some of these family members. So anyway, but I think we're going to wrap it up for now because I don't want it to get too long. And I probably have another hour's worth of questions for you. So we'll do another session next time.
That's
and so Sean, why don't you give them some contact information
Sure.
for yourself?
All right. My office number is 443-292-6400, and I'm option 9. That'll get you to the law office of Sean Bittinger and Maryland Title Group. My email, if you wanted to send me an email, is Sean, SEAN, at mdtitlegroup.com. Sean at mdtitlegroup.com. If you need anything, please feel free to, drop me a line, give me a call, and I'll be more than happy to talk to you.
Now, what area do you cover, Sean?
As far as all of Maryland.
All of Maryland. So anywhere in Maryland you can do. And yeah. So, okay. And that's good to know. So everybody, he can do refinances and help you with other things, short sales, and other kind of consultations if you have questions. So
yeah, absolutely. I'm more than happy to talk to somebody if I can do the minute clinic and give them. That's no problem to do. It's something that I can solve quickly for them or put them in the right direction.
Right. Yeah, and I appreciate that all the time because sometimes I need those minute clinics
there we go.
Just to make sure I'm heading in the right direction or advising my client the right way to take care of something. So anyway. Thanks. I think we'll log off for today, and I hope everybody enjoys it and reaches out if you have any questions. So I'm Bonnie Fleshman. And we're out. Thank you.
All right. Bye. Thank you. Bye.
Bye.